Are we now recording, Ms. Cannington?
We are.
Okay, thank you. Good morning. We are here today for a public deliberation in the matter of Pikesville Hospitality, LLC, case number CBA-21-017. On January 25, 2002, we held a hearing to consider three motions and related collateral matters. We'll be discussing our deliberation on those motions today. I'm Adam Sampson. I'll be hosting, or I guess chairing, this hearing. With me are my colleagues Fred Lauer and Brian Pennington. So, gentlemen, we're charged with deliberating on these motions. I will tell you some of my initial thoughts, if that's okay to proceed that way. As I had invited counsel to submit additional filings if they chose to address an issue that Mr. Nelson had raised, contending that this board is bound as a matter of law by a prior decision in another unrelated case with a different panel, and to take a different approach in Mr. Nelson's view would be arbitrary and capricious. And I took issue with that, and I still do, for reasons that I think are obvious, but also that the Developers Council highlights, which underlie my reaction at the time. Certainly, cases are distinguishable on facts, procedure, and law. Cases cited in the submissions don't change that. Mr. Nelson, I think it was Mr. Nelson, doesn't matter. One of the submissions indicated, quoting language, that the standard would be irrationally inconsistent if we were to take a different approach. Another case mentioned in the plural precedents, and that case dealt with a remand of the same case but to a different panel. All of the cases, including Lascotti, are distinguishable from this case. However, in my view, while it's not binding, it may be instructive, but I give it little weight. I do, however, conclude that we should stay this case and remand it. I'm troubled by issues of being diplomatic here. Transparency is a strong word, but it's difficult to know when an appeal could or should be noted. There's certainly a disagreement of timing here and what could be appealed and what couldn't, and when notice was provided to trigger a time for appeal. In my view, though, that we should remand to the director of PAI and the ALJ specifically to evaluate whether the proposed development is a planned drive-in cluster. It may be that the case still comes back to us on appeal, but we'll have a record, even though it's a de novo case, we will have a record to understand a specific finding and a basis therefore that I believe we may not have now. I do think it furthers the interests of judicial, or in this case, quasi-judicial economy. And I do think it's important that the public have confidence in the process. If it resolves below, like other cases have, then there won't be a need for further proceedings here. But by staying it, if there is a need, then it would return here. And so my view, in addition to that, I would be denying all of the motions because they're for dismissals, and I don't think we need to dismiss at this point. Those are my views without getting hyper technical. I spent more time addressing the subsequent memos just because they were at my instruction or request or suggestion, and I thought they deserved to be addressed. So I will turn it over to whomever would like to weigh in next. Do I have you guys muted?
No,
Oh, there you go.
I'm good. I'll go ahead, Mr. Chairman. I agree with you regarding the Lascotti case. I don't see an obligation for us as a board to follow that. Aside, I think there are different facts. It is a different statute. There's questions about the timeliness of the appeal in this case as opposed to the other case. But in general, I think that this panel doesn't have to follow, has no obligation under what I've read from the briefs that were given by counsel here. A concern I have, Mr. Chairman, is that when is there finality in cases like this? You know, this started out a couple of years ago, and maybe we'll get that through remanding it to the ALJ and letting them take a look at this. But you know, for a developer, I think it's very difficult. You know, you get approval from planning and you go through the various agency things, and you look back at the statute, and maybe the statute isn't constructed quite the way some people would have it, that in these cases they would prefer a special hearing. I get that sense from what the testimony was previously. But my big concern is in terms of kind of sending this back again. It has to do with the finality in the case. I mean, you know, this was 2018. It's 2022 now, in terms of development, etc. And maybe this is the best way. You know, and I think it was suggested by some counsel that if in fact this does go up and then come back, we got another 2 years of playing around with the thing, and maybe the best way would be to stay it as you and basically remand it as you suggested, Mr. Chairman. But I guess, you know, listening to both sides of it, you know, the vesting and finality both kind of, in my mind, come into play in a situation like this, trying to figure out, you know, how to balance all of that out. So that's kind of my initial thoughts on your two comments.
Yeah, I would respond simply by, I certainly, again, maybe poor choice of words. I'm sympathetic to the length of time that it may cause or the other concerns that a developer may have, but I do think there's a balance that has to be struck, and that's the challenge I think we have. As I mentioned, the public's interest in the transparency of the proceeding, and also the specific opposition here in knowing what and when it has a right of appeal. I don't think these cases have easy answers. I do think some of them tend to go on very long and others don't. My quarrel may be more with how the law is set up in the first place, but that's what gets us here. It's just unlike my practice of law in other areas that are more refined. This seems to be an area that lends itself to very challenging procedural questions, and I didn't come to this lightly. I just, for the reasons I said, and maybe they're not sufficient enough, but I think that's why we would stay and remand it, to get that clarity, and then the next step hopefully would be, in whichever direction it goes, to get more quickly to that finality that you think it warrants. Mr. Pennington?
And I would agree with you, Mr. Chairman. You know, the problem with this case is, as you both made mention, when is it final? When is the decision final? Is it, you know, as the counsel for People's Counsel, they argue that that all the steps are interlocutory. I spent a lot of time researching this, and I could not find any straight answer. at first glance, the letters from the first letter from the PAI in September of 2018, they granted the limited exemption, and then there was a following letter, and then there was even a letter that at some point in, I believe, October of 2020, that said, this is our decision by the DRP, and you have 30 days to appeal it. But where is the line? There needs to be something more clear cut as far as when something is final in this case. So I understand both sides. I mean, this case has been going on since 2018. I know these developers have quite sure have invested a lot of money in this, but I think what you suggested, to remand it to get to where we need to be, I think that's the right answer. And as far as Lascotti, I agree with both of you. I think Lascotti is factually different in both, and even so, even in the opinion in Lascotti, they made mention that it needs to be legislatively corrected, clarified. So I don't see any issue with us deciding either way and not gelling with Lascotti.
Okay. And as a collateral matter, I don't see the need to decide one way or the other whether People's Council has standing in this appeal, if I'm using the right term, standing to participate in this appeal. One, because we're going to stay it, and I suppose if it comes back, we can take it up then. Two, though People's Council participated in the oral argument and written submissions, I believe those same bases were addressed by Mr. Nelson, and in any event, we can take those up, I think, on our own initiative. So I believe those issues are properly before us that we've considered and just made the determination to stay and remand. So I'd like to hear from either of you if you want to comment on that issue.
I agree with you, Mr. Chairman. I think if it comes back to us, we can deal with it then.
Okay. Anything, Mr.
No, I agree. I
think
there was another issue with the bill 5318, I believe, correct?
Yes, and I think we need not address that either.
Great.
Okay, so
Great.
I think I'm procedurally correct when I say then that we would be denying the motion for partial dismissal of the appellee developer. We would also be denying what was pled in the alternative or moved in the alternative as the appellant's motion for summary judgment, and we would be denying People's Council's motion to dismiss again, because we're not granting any of that relief. We're simply going to stay the case and then remand it for the further proceedings as outlined. So that would be the ruling. I'll have to confer with Ms. Cannington on what needs to be put in writing and when, and we'll handle that. Is there anything else that either of you wishes to add?
I have nothing further. Thank you, Mr. Chairman, and I'm in agreement.
Nothing.
Okay.
Thank you.
All right, well, I think that concludes our deliberation in this case for today, and I will be exiting the meeting. Thank you both.
Thanks.